Good afternoon. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our March 15th, 2018 public meeting. Section 282 of the New York State multi-dwelling law establishes the New York City Loft Board. The board is charged with overseeing the timely conversion of inter-multi-dwelling buildings from commercial and manufacturing spaces to safe rent-stabilized residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State multi-dwelling law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. We will first turn to a vote on the minutes from the February 15th public meeting. Are there any corrections or comments to these meetings? To these minutes?
I have a question.
Mr. Delaney.
In your report last month, also you talked about the notice of violations that were sent to owners who failed to file monthly reports.
Right.
And noted that steps to deal with recidivists are under discussion. I was curious if those discussions have yielded any conclusions.
We haven't had a chance to really focus on it. It's a very short month between February and March.
Short month, yeah. That's my only question.
Okay, great. Is there a motion then to accept the minutes? Someone? Thank you, Mr. Shachter. And the second would be Mr. Hernandez. Ms. Rivera.
Mr. Carver.
Yes.
Mr. Bauer.
Yes.
Mr. Walsh.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Shacker.
Yes.
Chairperson Hilton.
Yes.
7 in favor.
Thank you, Ms. Rivera. Ms. Balsam will now, she's the executive director of the Law Firm, and I'll give her a report.
Thank you, Chairperson Hilton. I want to take this opportunity to remind the board members that when the cases come back from oath with their reports and recommendations, we get a tremendous amount of material from oath. We get all of the transcripts, all of the exhibits, all of the pleadings. And staff reads everything and picks and chooses what to send to you. It is possible that there might be something that you want that you didn't receive or that you don't understand what we sent you. So I want to remind you, board members, that we are there to help you with that, to provide you with any additional materials that you want. And of course, the entire record is always available, and I know some of you have availed yourself of the opportunity to come to the board's office for inspection if you want to do that. So I just wanted to remind you of that. Our revenue for February was unofficially we collected $1,833.78. We had a request for statistics on heat complaints, so I have distributed to the board members a little chart that we developed on the heat complaints. So there were 24 buildings where we had complaints called in. Some of them, most of them were no heat.
One second.
Is there a problem?
I think everybody can't hear you.
Oh.
Maybe put your own notes.
Hello? Is that better? Okay, sorry. I thought it was on all the time. Anyway. Heat complaints. So we had a request for a report on heat complaints. So we put together a chart. There were 24 buildings. Most of the complaints were no heat complaints, but some of them were too much heat. One was that the heater was blowing out fibers and rust particles. For the most part, those complaints have been resolved. The chart shows that 7 buildings have unresolved complaints, but since we did the chart, actually, I found out that there are 2 other buildings where the complaint has been resolved, 59 Crosby and 54 Knickerbocker Avenue in Brooklyn. And you'll note that most of the complaints are resolved in the same day. Some of them you can't because it involves a lot of work, but for the most part, we try and get the complaints resolved in the same day by speaking to the tenants and the landlords. In terms of registrations, we still have 19 buildings that have failed to register. And in terms of litigation, the protected occupants at 79 Lorimer Street brought a housing court action in Kings County, asking the court to fix the conditions in order to get the vacate lifted and restore petitioners to physical possession. asking for a harassment finding with punitive damages, and if the owner fails to comply, the tenants would like the court to direct the city to enter judgment against the owner for penalties. And the Loft Board was a named party in that action.
Do we have the papers on that?
Not with me, but yes.
Yeah.
Yeah.
Okay, I'd like to request a copy.
Sure. Any other questions?
You said the Loft Board was or was not a named party?
We are a named party.
Was.
But really, it's a dispute with the owner. Okay?
I'm sorry, I do have
Yeah.
one other question. You mentioned that the staff picks and chooses what gets sent out in cases to the board members.
Well, we choose the stuff that's referenced in the decisions.
Right. And I realize, and there's someone who has availed himself of the opportunity to come visit the board during business hours to look at other case materials. The one problem that I have realized is that it's kind of hard to know what else might be there, and therefore hard to know whether it merits a trip to go take a look. And we had some correspondence on this matter, and I suggested maybe there was some way to provide a summary of what's available, and I realize that that might be onerous, but I just want to note that I'm still have a concern in that area.
Well, a lot of the cases come back with summaries that are done by the ALJs. They keep exhibit lists, so those we could certainly send out. And that's not a problem, but for us to actually put that together would be very burdensome. Because as we said, there's lots and lots of material that comes.
I think adding the exhibit list would be at least a good start.
Where there is an exhibit list, we have no problem adding it.
Is that,
I'm sorry, do you mean to automatically send out the exhibit list or just notify?
I mean, I think if
Look.
the board wants the exhibit list in the backup package, I have
Is that
no
what you-
problem
well,
with that.
let's be frank, most of the time, and I know you've worked hard to improve on the previous board administration in terms of getting cases out to board members, but we don't get a lot of time to work with these cases, and therefore, for me to say, oh, is there, right, you would say, is there an exhibit list for this? And if so, can you send it? If there is one, I think it should just automatically go in the package. And my follow-up question would be, with regard to creation of exhibit lists, is that kind of under the, discretion of an oath judge, or do they, why don't they all do that?
They may all do that, but I can't say in a given case, we might not get it for some reason, but where we have it. I mean, as someone who was a hearing officer for many years, I always had exhibit lists. And I think that the oath judges certainly do because the cases are so complex. But I can't guarantee that that's going to come in every case. So when we have it, we are certainly happy.
So Helen,
to
can we
include it.
request, if one comes without a list, can we request it back from both?
Well, I don't know. We can ask them if they have it.
They
I
have
can't
it,
ask
yeah.
them to make it.
Sure.
So,
So maybe a little diligence there, but once the cases come back, we can always check to see and ask for one.
I think that would be helpful.
Just a odd question. Do we have any idea what the backlog of cases that are sitting in the office, or whenever they come be presented to us?
no, I can't say that whenever they come, we present them to you.
Okay.
We do have a backlog. We are getting 2 summer interns this summer, so I'm hoping that they can really tackle the summary case backlog.
Okay.
If you want statistics on that, we can report on that next month.
Any other questions for Ms. Boston? Thank you, Ms. Boston. We now turn to a vote on this month's cases. We start with the appeals and reconsideration calendar. There is one case on this calendar, that is Quarry Plaza LLC, 79 Quay Street. Quay Plaza LLC, 79 Quay Street, Brooklyn, docket number AD0085. Mr. Bobbitt will present.
Thank you. This administrative appeal challenges the Executive Director Balsam's denial of owner's request for an extension of the code compliance deadlines. Pursuant to 29 RCNY Section 201B2i, the Executive Director may grant an extension of the code compliance deadlines only where an owner has demonstrated that the necessity for the extension arises from conditions or circumstances beyond its control and that owner has made good faith efforts to meet the code compliance deadlines. An owner applicant must submit corroborating evidence demonstrating this standard. The failure to include such evidence in the application may be grounds for denial of the application without further consideration. In the administrative determination, Executive Director Balsam found that owner failed to meet this standard. Specifically, owner failed to demonstrate that it had exercised good faith efforts to achieve code compliance. At the time of the filing of the extension application, the only progress made to achieve code compliance was owner's alleged retention of an architect, proof of which was not provided. Prior to issuing the denial, Executive Director Balsam requested a copy of the retainer agreement, but owner failed to respond. In the appeal, owner stated that it believed the filing of the Alt 1 with the Department of Buildings and the narrative statement with the Loft Board, coupled with owner's sworn statement in the extension application that it had retained an architect, would have been sufficient proof that owner exercised good faith efforts. Staff disagrees. The filing of the Alt 1 application with the DOB and the filing of the narrative statement with the Loft Board occurred after the filing of the extension application and after Executive Director Balsam's request for the retainer agreement. If owner wanted these actions to be considered, owner could have responded to Executive Director Balsam's request. Staff recommends that owner's administrative appeal be denied.
Thank you, Mr. Bobbitt. Does anyone on the board has any comments or questions? Is there then a motion to accept this case? Mr. Delaney? A second. Mr. Barros. Then Ms. Rivera?
Mr. Howard.
No?
Mr. Bauer.
Yes.
Mr. Roach.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Shachter.
Yes.
Chairperson Hudson.
Yes.
6 in favor, 1 against.
Thank you, Mr. Rivera. There are 8 cases on the summer calendar that are voted on as a group. However, we will vote on case number 4 separately. So I'll read cases 2 through 9, and then I'll come back to 4. This first case on the summer calendar is Robert M. Rossi, 870 Broadway in Manhattan, and that docket numbers are P00018 and TA0211. Secondly, Neil Fenton, Cynthia Sobek, Annabelle Oxford Mersberg, and Lars Mersberg, 322 through 324 East 3rd Street in Manhattan, docket number P00049. The next case is Rad Rubini, 78 through 82 Reed Street in Manhattan, docket number P00063. Next case is Jill Frink, 78 through 82 Reed Street in Manhattan, P00064. Then Carol Ekman, address is 598 Broadway, Manhattan, docket number TA0245. Then Neil Fenton, Cynthia Sobek, Annabelle Oxford Marisburg, and Lars Marisburg at 322 through 324 East 3rd Street in Manhattan, docket number TR1332. And finally, Alex, Acadia, Benjamin Oliver, Noah David, and Elizabeth Smith at 371 Canal Street in Manhattan, docket number TR1357. We'll vote on these cases as a group. Does anyone have any comments on these cases? Then is there no comments? Then we have a motion to accept these cases. Mr. Carver, is there a second? Mr. Schacht. Mr. Schacht. Okay, Ms. Rivera.
Mr. Carver.
Yes.
Mr. Roberts.
Yes.
Mr. Roach.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Mr. Shachter.
Yes.
Chairperson Hudson.
Yes.
7 in favor.
Thank you, Mr. Rivera. The last case on the summer calendar would be Laura H. Bond, 83 through 91 Meserole Street in Brooklyn, and docket number is PO0052. Does anyone have any comments on this case?
Yes.
Yes, Mr. Delaney.
This case is one where a tenant filed for protected occupant status in a building on Meserole Street in Brooklyn. The landlord alleged that there was a prior 286-12 sale. At some point, the former tenant, who either did or didn't enter into a 286-12 sale, provided the applicant with a sworn statement that she was not compensated for her rights. As has been the practice of many owners who file a sale of rights form, the purported sale of rights was filed with the sale amount blacked out. My intention is to not vote for any case on any calendar until the board changes its rules to not accept 286-12 sales where purchase price has been blacked out by the owner, which is currently an option that's given. In discussion in the private session, I think it's fair for me to state that it was agreed that this topic will be on the forthcoming agenda for discussion by the board members. It's no secret that in the last few months we've seen more and more contested 286-12 sales. One of the cases on the summary calendar involved, that we just voted on, involved a rather notorious bad owner in the 1980s and 90s. But by God, the 286-12 sales were filed at the time that the sales were made, prices were disclosed. There is a way to do it right. So the fact that so many of these nowadays seem to be done wrong or done haphazardly or filed 20 years after the fact with no signatures is something that needs to be corrected.
Thank you.
And I plan to vote no on this case.
Thank you, Mr. Delaney. Do we have a motion on the board to accept this case? Mr. Hernandez, is there a second? Mr. Carver. Ms. Rivera, could you please call the board members?
Mr. Carver?
Yes.
Mr. Barrett?
No.
Mr. Bush?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
No.
Mr. Shackler?
Yes.
Chairperson Hilton?
Yes.
5 in favor, 2 against.
Thank you. The motion is carried. All right. There are 4 cases on. Yeah, there are 4 cases in Mascot, including 2 removal cases. The first case is Michael Freemuth at 473 through 493 Kent Avenue in Brooklyn. Docket number PO0067. Mr. Clark will be presenting this case.
Thank you, Chairperson Hilton, board members. On June 15, 2017, tenant of Unit 501 filed an application seeking coverage pursuant to 281.5 of the multiple dwelling law and protected occupant status. On October 13, 2017, O sent a final notice of trial to tenant advising him that under 29 RCNY section 1-06K4, if tenant failed to appear, the application may be dismissed with prejudice. Tenant failed to appear on the scheduled trial date. In the report, Judge Zorganati recommended the law board dismiss the tenant's application with prejudice for failure to prosecute pursuant to section 1-06K4 of the Loft board rules. This section of the Loft board rules states, if an applicant does not appear for a hearing which has been marked final, the application may be dismissed for failure to prosecute unless there is an approved request for this reinstatement, which must be made within 30 calendar days from the hearing date. It has been more than 30 calendar days since the final hearing date. Tenant did not file a written request for reinstatement. Staff recommends the board accept Judge Zorganati's recommendation to dismiss the application with prejudice for failure to prosecute.
Thank you, Mr. Clark. Does anyone have any questions or comments on this case? Do we have a motion then to accept this case? Mr. Carver, the second. Mr. Hernandez, Ms. Rivera?
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Roach?
No.
Mr. Hernandez?
Yes.
Mr. Delaney?
No.
Mr. Shafter?
Yes.
Chairperson Hudson?
Yes.
5 in favor, 2 against. Motion passed.
Thank you, Ms. Rivera. The next case on the master calendar is a removal case, and that is, I just hit one.
It's not.
Oh, it's not a removal, I'm sorry.
I did that last week too, I'm so sorry. Okay.
I apologize. The next case on the master calendar is, the applicant is Caitlin Wade at 473 through 493 Kent Avenue in Brooklyn, docket number TR 1253. Mr. Bobbitt will be presenting this case.
Thank you. The tenant applicant in this case seeks the finding of protected occupant status for Unit 603. While the case was pending at oath, the parties agreed to have the issues decided on the papers. The two issues here are whether the unit is subject to rent regulation, and if yes, whether tenant is the protected occupant of the unit. Owner argues that in November of 2011, prior to the start of tenant's tenancy, the prior occupant's estate agreed to sell the rights and improvements to owner. Owner asserts that this agreement is documented in a series of emails exchanged in November 2011 and then memorialized in the July 2012 agreement well after tenant's occupancy of the unit began. Staff disagrees. The November 2011 emails do not amount to a sale of rights. There's nothing in the November emails that refer to a sale of rights pursuant to MDL 286-12, and there's nothing in the July 2012 agreement that refers to the prior negotiations alleged to have taken place in November 2011. At most, the emails discuss a possible sale of improvements. The July 2012 agreement is not a valid sale of rights either. Section 210A1 states that a residential occupant of an IMD unit may sell the rights afforded such occupant pursuant to Article 7C. In July 2012, Mr. Hetherington was not a residential occupant of the unit that was not in possession. Therefore, the July 2012 agreement and the sales record form are not a valid sale of rights pursuant to MDL 286-12. Staff recommends that the board find that the unit remains subject to rent regulation. With respect to tenant's protected occupancy claim, Judge Miller found tenant to be the protected occupant of the unit pursuant to 209B3 because tenant took possession of the unit in December 2011 pursuant to a lease with the owner. However, staff rejects Judge Miller's analysis under Section B3. Subsection B3 does not apply. Tenant took possession of the unit pursuant to lease, but the lease is not in effect. As a primacy of the unit without a current lease, the correct analysis is under subsection B4. However, because there was no hearing, the record does not contain enough information to determine whether the unit is tenant's primary residence. Staff recommends that the board reopen the record to allow for the submission of information and documentation filed with the law court on the issue of whether the unit is tenant's primary residence.
Can you just mention the change in the law?
In the order, we made a change to make sure that the documents are going to be filed with the law court. And after they are filed with the law court, such documents must be filed with the law court within 45 days of the mailing of the order.
Can you read the sentence that was changed? Please.
Conclusion. The law court directs the parties to file information and documentation on the issue of whether the unit is tenant's primary residence. Such information and documentation must be filed with the law court within 45 days of the mailing date of this order. Failure to file such information or documentation with the law court may result in the denial of the tenant's protected occupancy claim. If the information or documentation presents a factual dispute, the law court directs the staff to refer the tenant's protected occupancy claim to oath for further fact-finding. If the information or documentation does not present a factual dispute, Staff will present the case to the Loft Board again for a final determination on whether tenant is the protected occupant of the unit.
Thank you, Mr. Bobbitt. Does anyone have any comments on this case? Yes.
Yes, I plan to vote against this order and encourage my colleagues to join me. I had advocated that we accept the report and recommendation as it was presented by the oath hearing officer. The circumstances, and I agree with one portion of the existing order. I think it's clear that the transaction that took place between the landlord and the estate of the deceased prior tenant, Mr. Hetherington, did not constitute a 286-12 sale. And the fact that the owner opted to enter into a new lease with the applicant prior to even having finalized the transaction with the estate is further sign to me that there was no 286-12 sale contemplated. And the fact of the matter is that the prior tenant was an award-winning photojournalist. And his sudden death obviously caused some confusion with the communication with the executrix of his estate, who was his mother, who lived in Great Britain. It would appear that the discussion turns on the question of whether or not the oath judge interpreted or applied the right section of the Loft Board Rule 2-09. It's been my position over the past 5 years that the Loft Board has no business looking to 2-09 in any kind of coverage case other than cases where there's a dispute over either subdivided units or sublet space. And in this instance, the new tenant, who is the applicant, signed a one-year lease in December of 2011. And the board has decided to ask for this additional information, as far as I can tell, in part because the board believes that the wrong section of 209 was applied. My position is it doesn't matter because no part of 209 should be applied to this kind of single unit coverage case. And the other fact that the board's opinion turns on is that the tenant applied in March of 2014 after that one-year lease had expired. Well, I applied for coverage in my building approximately 14 years after my last lease had expired. No one asked me to prove that I used it as my primary residence. I think this is a wholly unnecessary test. There's a proper avenue if the owner of this building believes that the applicant is not the primary residence unit. There's a way to register and then bring a non-primary residence case in the appropriate legal channel. The mere fact that a one-year lease was granted, everybody in my building currently either has no lease or has no lease and has had one-year leases that expired years ago. So in my mind, this is really wasting the applicant's time. Not that I care that much, but maybe wasting oath's time. And really is asking people to supply documentation of something that has no real practical or legal reason to be required. Therefore, I plan to vote no.
Thank you. Does anyone else have any comments on this case? Mr. Rowe.
Mr. Chairman, as with case number 10 and also here case number 11, first of all, I want to commend the individual staff attorneys for their diligent and hard work on these cases, as well as the Loft Board staff as a whole. However, I'm going to vote no on this case as well. I simply need more time to review this case and digest all the information.
Thank you, Mr. Rowe. Does anyone else have any comments on this case?
You know, actually, I would like to say something positive.
Thank you.
In the conclusion, the staff is having the applicant provide factual information, and we've decided that the staff would evaluate that information and then decide, if necessary, to send it to oath if there's any conflict in the facts.
Well, I believe it was if there is a challenge on the information, right? Is that the case? If it's factual dispute, meaning, yeah.
Same thing that I recommend. And so this is, I think, a good, practical way of moving things along. And I hope you'll continue to show that flexibility with all parties and in other cases.
The board will always apply the law and the rules as it to all cases fairly. Thank you, Mr. Carver. Is there any other comments on this case? Then is there a motion then to accept this case? Mr. Hernandez. Is there a second? Mr. Schechter. Thank you, Mr. Rivera. Could you please poll the board?
Mr. Carver?
Yes.
Mr. Roberts?
No.
Mr. Roche?
No.
Mr. Hernandez? Mr. Delaney?
No.
Mr. Schechter?
Yes.
Chairperson Henson?
Yes.
4 in favor, 2 against, motion to not carry.
Okay, so this case has not passed motion.
Yes, it has.
I think these motions now pass with 4.
4.
Oh, fine.
Okay, thank you. The next case,
Excuse me. I know that several months ago, you made a statement in the public meeting, Ms. Balsam, with regard to the number of affirmative votes needed to adopt a case. And I wonder if you could just summarize that for the benefit of the public.
Yes, there was an issue raised as to how many members are required to carry a motion if there are vacancies on the board. Unlike many boards, the enabling legislation and the executive orders that establish the Loft board say that the board will consist of 5 to 9 members. So therefore, there's no absolute number of what is a majority. It depends on the makeup of the board at the time, as long as the specialized spots, owners, manufacturing, and tenants are filled. So it was the opinion of the law department that since it's a 7-member board at the moment, and the special spots are all filled, that you only need 4 board members saying yes to carry a motion.
with the current makeup.
With the current, right, because the specialized spots are filled.
Mr. Is there any new information about the 2 vacancy seats on the board? Is it going on now for rather several months?
We're told that the mayor's office of appointments is actually working on it, and there's definitely one person who's very close, and I think one other person who they are talking to, and somebody else that they're trying to reach out to. That's what we've been told.
Thank you. Are there any additional, sorry. We now come to the removal case. They are 873 Broadway Associates at 873 Broadway in Manhattan, and the docket number is LE0232. And the last case is 31 Cooper, Inc., 27 through 31 Cooper Square in Manhattan, docket number LE0668. Does anyone have any comment on this case? These cases, I'm sorry. These, their motion then to accept these cases? Mr. Roche, and I see Mr. Borowitz is second. Then Mr. Rivera, could you please poll the board members?
Mr. Carver?
Yes.
Mr. Roche?
Yes.
Mr. Roberts?
Yes.
Mr. Roche?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Mr. Schechter?
Yes.
Chairperson Henson?
Yes.
7 in favor.
Thank you, Mr. Rivera. So we're now returning to discussing rulemaking. Board members received an updated copy of Chapter 1. There are some open issues to resolve, and we hope to turn to Chapter 2 next month beginning our April meeting. And Ms. Balsam will begin the discussion where we left off.
So, returning to Chapter 1, the updated version that I sent to the board members is basically the same with some definitions from Chapter 2 moved in, because as we were working through Chapter 2, we moved some definitions from Chapter 2 into Chapter 1. So you'll note that in 1-12, which is the definition section, we have added definitions for continuous pattern of behavior, escalator, family member, garbage removal cost escalators, harassment, ongoing course of conduct, protected occupant, and reasonable and necessary action to obtain a certificate of occupancy, RGB. We also added, in one of the open issues had been grandfathering, and the definition of grandfathering and what it really means, and it wasn't really clear to us. So we did some legal research, and we've changed the definition of grandfathering a little bit from what it was before. It's it's actually broader than it was, but we also added definitions for minor modification and administrative certification and special permit, which are a couple of ways, my understanding is, procedures where units can be grandfathered in. I don't think it's as relevant as it used to be when zoning was much more important in the law, but we wanted to get it right. So are there any questions on those definitions? Yeah.
First off, the last few times we've discussed rules, there have been copies available for the public. Is that the case today?
I didn't get a chance to make them, to be perfectly honest.
Okay.
But they're certainly available if anybody wants them.
How would one go about it?
They can just ask for them.
We just ask them.
Yeah.
Okay.
I mean, it would be better if they made a flow, because that would be tracking what's going in and out. So if that's not overly burdensome to send a flow, that would be better.
I would say flow request is a burden.
Well, it's a tracking mechanism for us, that's all. I mean, they're going to have to ask no matter what. So you can ask by sending in a FOIL request, or you can ask by sending in a request. When you write FOIL on it and when you don't. So I'm not sure how much more burdensome it is to write FOIL.
Okay. In future meetings where we discuss the rules, can we make copies available to the
Yes.
public?
Yes.
My next question would be, you've got quite a number of colors going on here in the definitional section. Is there meaning to the various?
The only one that's important is, I guess, the red, because those were things that might have been added to other things that we had discussed. Those are track changes. The red ones are track changes. The others are cut and pastes from other sections.
I don't have red, I have purple. It's like family members. Family member red?
No, I have a family member in blue, to be perfectly honest. Maybe it depends on the print.
It's a party, yeah. And yellow highlight is?
Just that, well, originally grandfathering and the two others were highlighted. I'm not sure why garbage removal cost escalators are highlighted, to be perfectly honest. So it should just be grandfathering, minor modification, and special permit that are the highlighted ones.
Okay.
Because that was the open issue. So,
That's definitely got a lot of color going for it.
sorry.
Okay, on the definitions, it would appear that, and there's quite a bit to read here because you have taken stuff that was originally in parts of Chapter 2 of it and put in the definition. So with the harassment definition, is that verbatim from what was in 2.0?
2B. I will double check, but yes, I believe it is.
And within harassment, it refers to any course of conduct. We then define ongoing course of conduct.
Again, these are definitions that were in 202B.
Which loops us back to continuous pattern of behavior, which we also define.
This was all there in 202B.
Yeah.
So it was just moved over.
And when you describe the grandfathering definition is broader than it was, can you just expound on that a little bit?
So the prior definition, where did that one come from? Thank you. Okay, so wait, before we move on to grandfathering,
Right.
let me just say that in terms of the definition of harassment, there was more in the original definition where there were examples given. Okay, harassment includes but is not limited to. So that we cut out those examples. Also, what harassment does not include, we cut out those examples too. And we also cut out the sentence, there is no requirement that the landlord's actions or inactions be illegal to constitute harassment. The law board may find a particular act constitutes harassment, whether it was directed toward one tenant or multiple tenants. But that's not really a definition, so that's an action section. And again, 202 is staying as is for now, so.
Staying as is for now.
Correct.
And
No, we're not changing to, right now we're not changing 202. Let me just take all of these out. Okay, so the other question was, I'm sorry, what was the other, on the other definition of grandfather? Right.
Why is harassment being quoted sometimes and sometimes not?
Again, that was carried over, I can take the quotes out. So I don't know why the original drafter did it that way, but I'll certainly take them out if you don't like that, it's fine. So grandfathering, let's go back to grandfathering. So, the sentence that's there now was the first sentence of the original rule, and then the original rule went on to talk about as of right use, and then had minor modification and special permit. So we took out the part about the as of right use because it's really not relevant anymore, because anything that's coming in now doesn't matter whether or not it's an as of right use. So you're no longer limited to as of right uses.
Given that the crowd doesn't seem too unruly, do you think it's possible to open the door and try to get some air in here before we start to lose people?
Sure.
I frankly don't know how much longer I can go on
Sure.
this weather.
I hope that's not the heat, though.
No,
Yeah,
that's
We
the
had
AC.
it on before and it was too hot.
yeah.
You can just open the door.
It's the AC, it's good.
Is it? Okay.
While they're doing that, can I just ask why New York City Loft is scratched through, lined through under executive director?
Because we don't need it, because board is defined as the New York City law.
I know, I remember some pretty healthy discussion over at the other building some months ago regarding the family members. How did we ultimately end up arriving at, I like what I see, but how did we ultimately?
This is the current definition,
That's the
that's in
current, okay.
2-08.1C3.
I had a few quick questions. So I noticed the definition of agent is an actual person as opposed to an entity. Is there a reason for that?
Well, person, it says it's the person in control, and person is defined as an individual, partnership, corporation, or other legal entity.
Okay, because as I read further in the agent definition, it says which
Oh.
person shall be 21 years old.
Oh, okay.
The entity can't be older.
Yeah, the corporation can't be more than, can't be less than 21.
I'm not sure it matters, but maybe something to think about. And
So should we like, if an,
I mean, this is the person that the owner is going to designate as the person to be called if there are emergencies and maintenance issues in the building, so that's why it's supposed to be a person. But I agree with you that it shouldn't say person, since person is a defined term.
okay, I mean,
So-
I just want to make sure that it makes sense. That's all.
Yeah, so maybe if we change person to individual,
Yeah.
okay.
Then back to family member just for a moment. So I see you cite to the MDL to define family, and then you talk about family member. Just want to make sure that some thought has gone into make sure that there's no conflict between the MDL family definition and your definition of family member. I just don't know.
Yeah, no, there is.
Okay.
so Ms. Paulson, so I sound clear, the agent here, agent is an individual.
It's an individual, yeah, we'll change person to individual in that.
So good catch, Mr. Cobb.
Okay, and then reasonable and necessary action, which is a few pages down on page 5.
Which what, 5?
Page 5, yeah.
Yeah.
Reasonable and necessary action. Is this language new, or is this coming from something?
Coming from 201.1A1.
Okay. And special permit refers to the Board of Estimate, right, which is long gone. Were you grabbing that definition from elsewhere, which is why you continue to use Board of
Yeah,
Estimate?
yeah, you want me to take that?
Not necessarily. I just want
Okay.
to make sure it makes sense. I mean, maybe there are still statutes that talk about Board of Estimates, so it needs to be referenced. maybe.
Right.
Okay, thanks.
So any other questions about the definitions in 101?
Yeah.
Okay.
Oh, yeah, we take it upon ourselves now to define narrative statement. Means a document that describes in plain language the proposed alterations to the alteration application utilization plan. There's a lot more specificity as to what needs to be included in the narrative statement. As I recall.
Yeah, but this is a definition of what it is. What needs to be in it is in the section that refers to narrative statement. A narrative statement must contain blah, 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 blah. And that's in chapter 2.
Right. But reading this, you wouldn't know that.
The purpose of the definitions is so that when you're reading the rule about the thing, you can go back and see what the definition is, how that term is defined.
Let me rephrase my comment. It seems like in harassment and ongoing course of conduct and pattern of behavior, we've gone out of our way to be quite thorough in defining it. Or here in the statement, it just seems kind of vague in that comparison.
So you want us to carry over all of the elements of a narrative statement into the definition?
I don't want to make that request without having had a chance to spend a little time with what's in chapter 2.
Okay, but we're not changing, well,
Why don't we just carry it over? Would that help? Would that, can we, why don't you take her offer, just bring it over, would that make it better?
If it makes sense.
We can also reference the section number in the
Yeah, I
definition.
hate cross-references.
Oh, you don't want to reference, okay.
You don't want-
Yeah, the only reason I don't like the
That changes.
cross-references, because then if we change the cross-reference, you have to go back and check and see if the cross-references are changed. And you get into lots of issues with that over the years.
Never mind.
So, yeah,
So, I'm just looking.
Like, I appreciate what you're doing in a sense. Insofar as in chapter 1, let's define everything that's not only used in chapter 1, but in chapter 2, and I gather there may be more numbers coming.
Yes,
Right.
hopefully.
So really, this is a definition section that applies beyond chapter 1.
Right. That was the idea, to put all of the definitions together, because right now, the definitions are scattered throughout the rules, and it's very hard if you're reading in one place, particularly, and there's tremendous number of cross-references now, so if something is cross-referencing something else, and then you go to that section, and you need a definition, then you have to go back to the first section to find the definition. And I just find that, to me, that's just untenable. So, I mean, I can put in more detail as to what needs to be in the narrative statement. If you want it there, I think that's okay.
I would ask you to take a look.
Okay. Okay. Okay.
I guess just to follow up on that, what is our goal in terms of what we seek to accomplish today?
Well, I'd like to finalize as much of chapter 1 as we can. I'd like to finalize chapter 1 and come back to you with a final draft that we could, not that we necessarily will, but that we could move and actually have a public hearing on. So to the extent that we could do that, that would be wonderful. But there are a couple of other open issues, like the settlement.
Right.
I'd like to resolve that, and then there was a question about the definition of primalist city. You had an issue about
Right.
that last clause. So, to the extent that we could get all of that resolved and have a chapter 1 document that's in publishable form, that would be great.
Just moving down the road, and my recollection may be incorrect, but I thought when we were discussing the rules way back in 2017, you had expressed the opinion that there'd be one hearing and one action to adopt all the new rules, or are you thinking now that we might do chapter 1 and finalize it and make those changes first?
I think that the revisions to chapter 2 are not going to be as extensive as I had originally envisioned, and so that we could do the revisions to chapter 1 and what will be revised in chapter 2 as one rule, but it won't be everything in chapter 2. It'll just be a few things in chapter 2.
So it'd be little chapter 2.
Well, it'll be less extensive changes to
At the end
chapter
of
2.
chapter 2, it won't say the end. It'll say go on to chapter 3.
No, there won't be a chapter 3.
There won't be a
I don't think there'll be a chapter 3 at this time. I hope someday that there will be, but I don't think I think we're gonna leave chapter 2 as a chapter and just change some of the rules in chapter 2. But if we could go back to chapter 1 now, because that was really what's on the agenda for today.
Yeah, no, I understand.
Yeah.
Well, we're here.
Yeah,
Yeah. I just, before we finalize chapter 1 with all these new definitions, I'm going to go back and look at chapter 2
that's fair.
for the definitions.
I agree. Okay. So any other questions about the definitions? Questions, comments, anything?
I mean, this is not really about the definitions and help clarify my memory. I apologize, but we have had that moment. Hadn't we discussed as a board that we wanted to try to bring in some per se subject matter experts from both sides?
That was on the issue of changing the sale of rights, but I think we're going to withdraw that proposal. So I don't know that we need to have the subject matter experts.
So we're not going to change the sale, we're not thinking we're going to change the sale of rights, so.
At the moment, no. Okay, so moving on. In 113, there are some minor language corrections, which were suggested. So in 113, 4, little I, and in 6, so any comments on those? Okay. All right, so then at 115, which is submissions to the board, it came to our attention that we don't actually have a rule that says anyone who files a false document with us is subject to a penalty. So we thought we should add that. So I'm asking the board to add a section to this rule. The board had previously approved this section, but I'd like to add a section that says any person who files or causes to be filed a document with the Loft board that contains a material false statement will be subject to a civil penalty. It shall be an affirmative defense that the respondent neither knew nor should have known that such statements were false. That comes actually from a DOB rule about false filings. So are there any objections to that, or is that okay? It's in the comments section, yeah. Well, I didn't want to add it.
What are we looking at with that as far as, I don't have a problem with it, but I'm curious as to,
We're seeking to take action against anyone who files any false documents.
what if in their opinion it's not a false?
Well, that's part of the affirmative defense. I mean, they would have a right to.
So we're taking that into consideration, that somebody's probably going to say, look, what I provided you wasn't false.
Right. I mean, it's not, we're not just that. It's not gonna-
I just didn't
They have
want to
to
add something
process.
that was going to create another problem somewhere else.
Anything you do will create a problem.
Yeah.
No, but that would do.
Okay, 116,
Are we in agreement that we're going to add that?
Yeah.
yes?
No, not at all.
Okay. All right, so on 116C, it currently reads a submission is not.
I'm sorry, still on 115?
Yes.
Section B, it seems to be saying that if there isn't a form, the submission has to be on plain white durable paper. But I know later on, we talked about electronic filing too.
Well, there's electronic and hard copy filing.
Right, but this seems to say if there's not a form, it must be on paper. Is that?
I see it.
Yes. What? It has to be on something. No, I think the point is that if you only have to do an e-filing, right? I think that's the point that you're making. If there's only an e-filing that has to be done,
And there is no form.
and there is no form, you want somebody to just be able to send an email and not.
So you just add something, language in there, copy.
So I would say, yeah, because everything that they're filing electronically and anything that's filed electronically and by hard copy, there are forms for, because we're saying you have to use the Loft board form. So if a hard copy, if the filing of a hard copy is required, and, no, is required, right, and a form is not available, the submission shall be filed on plain white durable paper. Because if they can file electronically, then the hard copy isn't required, right?
I was thinking utilize what you say.
It's required or utilized. Okay.
Given the oxygen deprivation, I'm more than happy to give you till next time
Okay.
to finalize the language.
Okay. I will finalize
Rather than what you
suggested.
think.
We're going to meet tomorrow, so we will finalize the suggested language.
Not the board.
Yeah.
The staff. Okay, anything else on 115? Okay, 116, C. It currently reads, a submission is not considered filed with the board until it is actually received by staff. Mr. Carver, you had sent in a comment saying by staff should we add in the office of the board.
Yeah, I was concerned that Martha might
Be walking down the street.
street and someone after her.
You know, it's interesting that you say that because that has happened in 280 Broadway where I haven't been physically in the office. People have actually handed me things. Yeah, so does anybody have any objection to adding in the office of the board?
Along those same lines, having recently had the opportunity to file some documents with the board, I was impressed with the speed with which everything was time-stamped the minute it left my hand. Is there any reason to add any comment with regard to receiving and being logged in or stamped?
You know, if you get too into the administrative procedures, then you box the staff into not having flexibility, so I don't know that we really want to go there.
Yes,
So I think we have a process, Irma set up a wonderful process that works really, really well. So,
Knowledge changes and.
yeah,
Yeah, I agree.
all right. Public access to records. There's been a whole lot of talk about business days, weekdays, blah, 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 so we tried to clear all of that up. And this one should be business days, so we're changing weekdays to business days. Okay, and then the next thing I have is 120.
Before we leave 117,
Yep.
when the Public Information Officer denies access to records in whole or in part, I assume that's via written denial?
Yes, along with, and it contains appeal rights. That's required in that FOIL.
That it be written?
Yeah.
Okay, so we don't know what's saying.
Oh, yes, that's correct.
Oh, yes, we don't.
We do not need to say that.
Yeah. And when I was discussing the fact that we withhold certain public information for FOIL requests, which is 117B, this was actually part of what I was thinking about in regard to the 28612 forms.
Well, so it's confidential information in leases. So again, this is all controlled by the public officers law, and it's the state that's setting the standards. So if there's something in the public officers law that says, you know, it's supposed to be, what you're withholding is supposed to be construed narrowly. The idea is to have as much transparency as possible. That having been said, the state has recognized that there's some information they really don't want to be releasing. So, again, I will look into it and see if there's something that we could hook onto in FOIL, but I'm not sure right now. Okay.
I just want to get straight what Mr. Leno was asking me, because I need to understand too. This is referring only to leasing, information in leasing, and not what we.
Yes, no, I
That's
understand.
right. But we could, theoretically, if it's allowed, we could just change this rule to say, all personal and confidential information contained in leases and sales forms, right? Maybe, so we could do that, if, assuming the law allows it. So that would be a good place to do it,
Right. If that,
if it's
something
allowed,
we, well, and the direction the board
if the board wants to go.
chooses to take.
It's a good place to come back to.
Yes, we will come back to here. Okay. No changes in 118, in 119. We had loft board and took out the loft part because board is a defined term and it defines it as a loft board. And then Mr. Carver, I think, had a couple of suggestions about 120. So the first is in 120A1. In the second sentence, the chair will place any matter on the agenda at the request of at least 3 members, with the chair determining when such matter will be placed on the agenda. Mr. Carver asks, does this sorry to talk about you in the third person. Does this refer to the date the matter will be placed on the agenda or the order on the agenda for a particular day? I think it's both, but I'm asking the board what you want to do. If you'd like that clarified in any way.
I don't think we should ever get too specific about these. Breathing room, seems to me.
So it's okay with everybody to leave it as it is?
So what does it mean by at the request of these 3 members?
So if the members say, put something on the agenda, the chair will put it on the agenda.
Okay. Does it mean that the board has to vote on it?
It depends on what it is that's being placed on the agenda. It could be something that's just for discussion. I think the FOIL stuff, the sale of rights stuff is a good example of something that.
So my question is, the way I'm reading it, so 3 members of the board request to put something on the agenda, and it says, the next statement says the chair determines when it will be placed on the agenda, and I think that's Bob's thing. So what if the chair says, well, next year?
2021. Well, the chair could do that. I mean, it's a request, a request from the board. It's a request from the board. I don't think it needs to be voted. Well, the chair does have the option
Actually, yeah, but
to
I'm talking.
do that.
Yeah. But I'm saying this request is coming from 3 other members of the board, and the chair is not in agreement. The chair could technically hold this off for a long time.
That's correct.
So do you want to clarify that?
Well, at the moment, this was written in a way that kind of gives the chair the option of, even if 3 members request something be discussed, to, in essence, prevent it from being discussed by putting it off for 3 or 4 years.
I don't like that.
Yeah, well, you weren't the chair that wanted this. He's currently on the MTA board. How would you suggest changing?
In specific to the request, I mean, can we clarify where, like 3 members, the 3 members of the board request that a matter be placed on the agenda? Can we say that the chair can determine if such matter will be placed within a certain time?
I don't think you should, and I think the word reasonable, there's a reasonable in there, it's,
Okay.
you know.
I'm fine with that, I just don't want to have indefinite in there.
You know, right now, we haven't had a major conflict between the members of the board and the director, unless the director feels as if he or she at some point feels that, you know, that they'll change their mind. I think we should just let it go, please. It's just not, doesn't seem to be a big deal.
I would like to limit this, I would like to limit the chair a little bit here by saying reasonable.
With the chair determining, with the chair placing the matter on the agenda within a reasonable time?
Isn't that open to speculation?
That's the point.
No?
Reasonable.
Okay, so,
If you put the word reasonable in, the chair can then either do it in a timely manner or not do it.
well, the chair could not do it now also, okay. The chair will place any matter on the agenda at the request of at least 3 members.
The chair
The chair,
reasonably,
well, the chair
Term-
will place such matter,
In consideration.
on the agenda within a reasonable time? Reasonable amount. Okay, so the chair will place any matter on the agenda at the request of 3 members. The chair will place such matter on the agenda within a reasonable amount of time. The chair may table any matter on the agenda. We're good?
All right? How does the chair feel about this?
The current chair is fine.
Okay, so then the next issue was 120A4, about the timing of the minutes. Staff prepare draft minutes of every public meeting of the board and make those minutes available to the board members and the public no later than 2 weeks from the date of the meeting. Again, Mr. Carver had suggested changing that to the next regularly scheduled meeting of the board, but the Public Officers Law, Section 106.3, requires a 2-week turnaround for the minutes.
okay, so
So,
that's the answer. But
yeah.
as you point out, then we're not,
Yes, we know.
okay.
Well, we have a new person that was hired to work on the minutes, so we should be able to meet our deadlines.
Okay.
Okay,
Number 5.
number 5, yes.
Before we record all public meetings in digital video format, I know the 72-hour requirement is part of the city council intro that caused this to be the standard
Right.
for agencies. And I know once or twice we've had trouble with video recording, so I know it's our practice also to make a backup audio.
Audio, yes.
But I'd like to suggest we put that in the,
Oh, it's required video, correct?
Yes.
Yeah.
Yes,
And you suggested we put the word audio here?
and a backup audio.
Oh, I don't think we should put your practice in the rule. I mean, what if we want to make two different videos?
Again, I think the language allows flexibility, whereas you're creating specific type of technology. It has to be audio. Maybe later on it's 3D imaging and now we have...
My point is not what the medium is, but that there should be, we have had at least 1 or 2 board meetings where there is no real-time record. And obviously, I'm sure that little device is over there, right?
Yep.
Yeah.
It's there. She's
It's
pointing
hidden by
to
the
it.
lectern, but yeah. So it just seems to me that it would be good to make sure we maintain that practice. Therefore, I suggest putting it.
Whatever the board members.
I don't think it has to be audio. I think you could reference backup.
Yeah, a backup, and a backup recording. Yeah, I'm not,
So,
no.
in addition, for recording, keep it simple.
Yeah, that's fine.
I'm not advocating that we change anything we discussed, but just hypothetically. So would I interpret that to mean if for some reason our camera went down and did something we not very functional, whatever we have? Because it says the board will record all public meetings in digital video format. How would we do that if the camera broke?
So the law requires us to do that, but I think the law also says there's some flexibility in the law that says,
Yeah, I mean, I know it's
you
never
know,
really happened.
it says
but we
like
did-
to the extent possible or
We
something
did
like
stumble
that.
last month, I think we got, somehow or another, something got whacked out of kilter and there for a few minutes, it was kind of dicey if we were working right again. So maybe the answer is just have a spare camera. But anyway, I'm okay with it, don't change it.
Okay.
I just want to throw it out there because technology does fail and that kind of.
But I don't know that we could say the
But
board
we
may
have a
record.
human
We
being
have-
monitoring the technology, right?
I think that we have to, I mean, the law says we shall report, so I think we can't make that the discretionary term.
So then my
But I don't know that the
question sort of
ramifications.
was,
No,
does
we
that
don't.
mean we cancel the meeting
No.
if the camera isn't?
No, we can still have the meeting.
Okay.
Okay, any other questions on 120? Okay, 121, there was a minor language change. Affected parties, 121B, there was a question about,
I'm sorry, before we go forward on 120,
back to 120?
yeah,
Okay,
and the reason I ask this is because I anticipate that the hearing or hearings that will be held on the rules are likely to bring forth a lot of commentary. And when the board was first established, in the early hearings, there was a considerable amount of questioning by board members of people who offered testimony. And then later, that was kind of arbitrarily outlawed. And personally, I think if you've got someone who, attorneys who practice, for example, who might want to comment on the changes to the rules, I think it's appropriate to be able to ask questions. So when that was changed under a previous administration, it didn't sit well with me. And I'd just like to see if we're clear on what the policy is.
so we've actually had this discussion before. I think that everybody who signs in to speak should get to speak. So to the extent that we have a lot of people that are coming to a hearing and want to speak, the purpose of the hearing is for the board to hear what the public has to say. And by the way, just throwing it out there, there are other ways to be heard as well, because you can file comments electronically, you can also file written comments, so just if somebody can't come. So to the extent that there are people waiting to speak, I think everybody who signs in should get to speak, and everybody gets 3 minutes. To the extent that there aren't a lot of people there, which I find highly unlikely in this environment, I'm more than happy to have the board ask questions and have things clarified. But I really would not want to turn people away who bothered to come down to a public hearing to speak because the board had a lot of questions. I just don't think that's fair to them.
Would the board be able to ask questions at the end if your time?
I don't see why not.
Well, but if big deal lawyer speaks number 3, the likelihood that
So,
he or she is going to hang out for 4 hours on the chance that,
I mean, bad lawyer at the end? No, I'm joking, but, can we go through the hearing process, get everybody speaking, and then ask questions, bring anybody else that board wants to ask a question at the end?
Again, I have no problem with that as long as everybody who wants to speak gets to speak.
well, I think one way to find a middle ground is if it's agreed upon that if someone in their 3 minutes says, well, I think this policy is wrong because of this, this, and this, that a board member or members be allowed to say, would you be kind enough to provide written expansion of your testimony to address this question, this question, this question, rather than get in, if there's limited time to avoid an ongoing dialogue, at least be able to say, I'd like to get more background on your position about
I think
your
that's a
second
great
point.
idea.
Okay, all right.
Although theoretically, there's a close as to when you can accept written comments, so let me think that through, okay? Because it may involve, in terms of how we publish, it may involve changes, so I think it's a great idea and we should do it. I just have to figure out the mechanism.
And the time frame.
Yeah,
Yeah.
okay.
Yeah.
All right. Okay. Okay, so back to 121. In 121A2, there was some minor language changes.
Material facts are redundant. And I think the word "thus" should be in there, and materials should be plural. In support of the materials where such documents exist. When I first read this thing, I couldn't even figure out what you were saying. What are material facts?
I actually asked for that change, and that's because you don't need to prove with the documents every fact, like my name is. So this is just related to those documents, where documents exist.
Could you, I'm
The
sorry,
document
for the benefit of everybody.
either is or isn't. So why does the document facts make it
121.
more specifically a document than just saying documents?
So the question is, what documents must be attached, right? So just those that you need to support.
Well, that's why I say...
A fact that makes a difference, basically.
Well, that's why I suggest the materials. And that way, it is up to whoever
Well,
to supply
I know,
the
but
materials. But I don't know why facts makes the material more significant. The word facts.
material facts, it's the adjective material, not the noun.
It's a legal term.
I
Material facts is-
understand it's a legal term. It's a bad term. It's a bad term, I mean, I wouldn't get into definitions of facts, but it's a sort of bad term. And it's not that it says that you have your facts, I have my facts. It's nothing to do with it.
So,
All right, that's,
What do
I
you
don't
wanna
want to
do?
make a big deal. That's what I was, the losing
Mr. Chairman, I have no issue with proceeding, but out of respect for my colleague, you obviously have to leave. Can we look at adjourning for today and picking up where we left off at the next meeting?
hold on.
Just want to see. We can try to commit to go through this quickly.
What's that?
We can try to commit to go through this very quickly to see if we can move through this.
I mean, the only thing,
I'm not opposed to that, but again, out of respect for my colleague, you obviously have to leave.
No, I think okay, I don't want to disclose that, but, what I would like to do is be able to wrap this up to the extent we can today, so by next month we can go into chapter 2. So if we, as Mr. Hernandez suggested, kind of commit to going through this real quick, unless there is...
well, if we could go to the settlements, I think that's
There's stuff
the
to
other
cover, right?
big open issue.
You still have a lot.
I
I'm thinking a lot, we were settled on.
So this is nothing new, this is stuff that we're coming back to you on stuff that we've already decided.
So I guess if we can ask, if there are clarifications that you need that may perhaps not require the board to be present, is that a possibility? Because if you're asking what does this mean, is that something that can be done privately as opposed to requiring the use of
I mean, I can certainly give anybody an explanation at once. To
Right,
the
no.
extent that there may be language changes in the rules, then the board will need to vote on it
No,
eventually.
I know, but if there's a question, so I was just looking at seeing how we can make this process a little bit more efficient and considering the conditions of the room right now. If there was a way of being able to ask questions that are pertinent to one individual, where that can be done one-on-one so that we could go over perhaps the edits that have been made. I'm just trying to find a way. I mean, again, I'm not trying to be disrespectful, just trying to find a way with the
We should probably just tread to them, Mr. Chairman. I'm not advocating we speed up either.
We're scheduled until 4 PM, so we should at least try to get there.
We should probably just try to tread to them. I don't,
Well,
I
I think we should jump to settlements then, because I think that's really the biggest issue. Everything else is really, for the most part, minor language changes.
And then we can come back. So
Yeah.
Let's go there, then we come back.
So that's one
what
dash
section?
30. It's 1-30 and it's on page 17. So this was, just to give the background, this was the idea that the cases that settled would go to staff first. And if it looks okay to staff, we would issue an administrative determination, which of course would be appealable to the board. But if there's something wrong with it or staff wants to bump it up, then it would go to the board. So that was the idea, and I know both Mr. Delaney and Mr. Roche were against the process, so we really need to decide which way to go. I was trying to save more work. If you want to keep the settlements, that's fine with me. We'll just use 106J5 as it is and make it 130. So,
Can we hear from the rest of the board? Or everyone?
Are you still?
There's nothing in my experience over the last few months that causes me to change my point of view. I find that many times there are pertinent issues, for me at any rate, that emerge out of summary calendar cases, and to make those administrative determinations, even though, and by the way, you've been very good at distributing administrative determinations. Have there been any since?
yeah, there's a couple that have to go out.
Yeah, see, I prefer having, if it's a case that's calendared, I think it should come from the board.
All right. Is there anyone who feels strongly the other way?
Yes, I do. I think in the interest of streamlining, speeding up, what's wrong with letting people settle cases? It happens in the courthouse every day.
Agree.
So you need to vote.
Mr. Rowe?
I'm going to stick with what I originally said at this point, just simply because I don't like to speed up and bypass, and forgive me, but I'm getting middle age. My mind can only comprehend so many directions going on
That's
at
okay.
one time. And
Do it time
we jumped we jumped a few sections. I really wasn't prepared to hit that yet. I didn't have an opportunity to really look ahead, so I'm going to stick with my original comment, which is that the board needs to see.
Okay. Mr. Horowitz, I just need to see if you have any, I need to kind of pull here.
I really don't quite know what to say. This seems to be a sort of particularly pertinent matter. And I don't know what language would best resolve it.
Can I say this then? If we're having any, this is not some sort of initiative for staff to kind of, take over and circumvent the board. So if there's any question about it on the board, or that staff, at least in the minority, so let's let's go back. I would suggest that we keep it as status quo. Okay? No, I have to have Mr. Hernandez and Mr.
I think if the opportunity presents itself for us to consider this,
How about another time?
Sorry, when you say,
Mr. Carl, I mean, I think that
what's the status quo?
The status quo is basically the summary calendar as it is.
as it is.
So you would keep all of the cases that are currently under the summary calendar, they would be processed the way that they are now. So you'd be doing the same amount of work that you're doing now.
The meetings will continue to be as long as they are.
Yeah.
Well, if we clear out the summary backlog, maybe not.
All right.
I mean, the only thing that has bothered me with the summer calendar over the years is parts of not only the redaction of certain things, but sometimes I don't really quite know. After reading the judge, I don't really know what the agreement is. And the agreement gets sometimes very vague.
That's fine, then that should be your reason for keeping the status quo. Right? Yes.
I'm very good with your decision, Mr. Chair. I just want to interject that my position is not based on distrust of anybody, but rather my thirst for all the information that I can get on something, because I feel that, I'm sworn to do a job here, and I want to make sure that.
So this section,
During my campaign.
I had nothing to do with the drafting list, but this section here, it's only trying basically to expedite matters that we think are, that staff could possibly do and give the board less work, because some of these things are, I want to say ministerial, but it's not, but it's stuff that could just be forwarded without much consideration, because we hardly debate summary cases. But, I mean, if the board is in any way unsettled with the idea, we should just continue to function as a board, the way we do. And if the executive director is comfortable with it, then I hate to be arguing on the other side of the fence. Yeah. So if there's any doubt, I just want to make it clear that this is not an attempt to take over or circumvent the board itself. So
it's only an opportunity to innovate. I think if we look at ways of being able to streamline the process without in any way hampering the will of what we're trying to do. So again, I hear your comment, and it's simply looking at different ways, and I think that's part of the suggestion. If it's not,
yeah, I'm trying to not let this piece be a hang up, because it doesn't. It is really trying to make your life easier. All right, so the decision will be then to, unless anyone else have any comments, then we'll go back to the way status quo, which is the ghosting.
I'll take the current language that's in 106J5 and I'll throw it in here.
Now back to,
Yeah. Oh, okay, so we were in 121. Okay, affected parties, I have a comment in there that there was a question was raised about staff sending the proposed order, and actually the board had agreed on this, I probably should have deleted that. That we're gonna post a list of owners who haven't renewed on the website and we'll incorporate that when the website is redesigned after the rule changes. I think that we should do that sooner rather than later, and we should do that posting now. So, I'm on 121B, the comment. The question was raised as to whether staff should send copies of FO orders to the tenants. That's the failure to register. So we're going to post the list of the owners who haven't registered on the website, and I think we should do that now. I was going to wait until after the rule changes, but I think we should do it now, because it's already been a long time.
we have the capacity?
Yeah, I think we do.
Okay.
We just have to figure out where to put it. So then the next change I have is in 121D1, where we're changing regular mail to first-class mail.
What's the difference between regular mail and first?
First class, it's now called first class mail, so you might as well use the right title.
That's not
Construction
construction.
is construction.
Hope it's good.
Okay, so on filing of the applications with the Loft Board, which is on page 12, E2, one electronic copy of the E2II, one electronic copy of the application in a format required for electronic copies as listed on the Loft Board's website, the application fee in the amount required by the board's rules.
So as I read this, this means that if I only file a hard copy, my filing is incomplete.
So if you don't have the capacity to file an electronic copy, you can apply for a waiver. But yes, you are supposed to file one hard copy and one electronic copy, but we recognize that there may be people out there that just don't have the ability to file an electronic copy. So there's a waiver clause.
Yeah, it was part of the discussion before, we talked about going on the electronic, and we said we want to find ways of being able to accommodate everyone.
Right.
Yeah, this was discussed.
I don't want to keep doing this, but once again, B, that sentence,
B? B what?
121.
B2?
D, we're going
V, I
back
think
To
it's
B.
E, two V's in Victor.
To B.
to B.
B is in.
Victor.
What's the name?
Oh.
That B, that's it.
Oh, the application fee.
That sentence is a poor sentence. It doesn't make any sense.
The application fee in the amount required by the law, by the board's rules?
It's just a matter of, it's too much chatter.
The correct application fee?
Is it in the amount? What if, Elliot, what if it's just the application fee required by the board?
That's all. Will be the amount required by.
Yeah.
The application fee will be the amount.
What was it?
Just take out in the amount.
Yeah.
The application fee required by the board's rules. Okay. All right,
I
Martha,
think the word B should be in there, but it's all right.
what? You think the word what?
Yeah.
Yeah. Mr. Bowers, you gotta speak in the mic or speak up a little
I'm
bit.
sorry.
Okay.
But-
Yeah, gotcha. I'm sorry, I didn't hear the last thing you said.
Just change.
You just chatting.
All right.
We're all gonna fire a roach for stealing the mic from me, so
I'm sorry.
On E4, on the same page, Martha suggests that it should say staff will not process an owner's application unless as of the date of the filing, because that pertains to the registration renewal application, and tenants do not renew registrations. So, any objection to adding staff will not process an owner's application unless, as of the date of filing, the registration renewal application. We're good with that? Okay.
Okay.
In terms of filing applications with the board, in light of the fact that we're currently barred by state law from accepting coverage applications, does that need to be addressed in the rules in any way?
No.
No. Okay.
Okay. So then the next, there's some minor changes, capitalization and stuff. And then we're changing on page 15 in 126C. When staff refers an application to the board for determination, any member of the board who has communicated instead of had a communication with a party to the application without notice, blah, 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 shall disclose. So that's just a minor word change.
Perfectly good, long English sentence.
Would you like me to make it into two
No,
sentences? Okay.
no, perfectly good, long
$124,800.
124A? Yes, okay, space. Be sure the law department will catch that. Okay, then the next change I have is in 128B, changing the last word of the sentence. Inferences adverse to his or her position may be drawn by the fact finder from such failure. So it's when a party fails to furnish documents or fails to submit, so we have refusal as the last word, it should be failure. And settlements we talked about, I'm going to change it back. That brings us to 131E. Prior, no, 131 CDE, yeah. Prior to the board issuing a decision, staff must post proposed orders on its website, etc. Proposed order shall not be part of the record of the case. And then some minor language changes in 1-32A.
In regard to the way 131E is currently phrased, issuing a decision, I would assume, would mean the date the signed order is mailed.
That's correct, because we're required by law to send a signed mail copy.
Right. So that could conceivably allow the posting of the proposed order after the meeting.
What?
The practice is now that we mail proposed orders to the parties.
Correct,
We don't want to do that.
correct.
The spirit of the discussion that we held was that the posting the proposed orders on the website would allow the parties, plus a wider audience, to examine the proposed order prior to the meeting
Right.
at which it's considered. But this language doesn't really.
So instead of saying prior to the board issuing a decision, you want to change the time frame to prior to consideration by the board?
Yeah, I mean.
That's fine, I think that's fair.
And it should be, obviously not the board's meeting at 2 o'clock and we're post the decisions at noon that day. There should be.
Well, I can't in good conscience say that we have to put a time frame in there, because then if we have something that we could send to the board at the last minute for a good reason, like for example, the first LE case, which was a very complicated case and
Yeah.
required a little bit more work,
Yeah.
we wouldn't have been able to do that case. That's a 20-year-old case.
Well, and I'm starting to feel like if it's not out by first thing Monday morning, I'm gonna refuse to participate. That was a lot to sort through.
It's up to the board members. Whatever you want to do is fine with me.
But you understand my point.
I understand the point.
I always ask for more time. It's.
Which I
Yeah.
refrained from doing, and in fact regret in one instance recently.
So the issue is whether or not we put in a time frame, right? Prior to consideration by the board, and we would put in a time frame, at least 5 days prior to the meeting or whatever.
Why don't we want to do that? Isn't
That,
fair?
I don't want to do it, Mr. Delaney wants to.
Again, when we put any restrictions, we decrease our flexibility, but I guess I just don't understand why we want to do that.
I would say to continue to follow roughly the policy that we had of letting the parties know in advance of the decision so that they can make an informed choice as to whether or not they want to carve out the time to be able to observe the deliberation of the board to the extent that the deliberation is now part public and part private.
Does it have to go into the rules?
Can I ask you, how would the parties know in advance that their case is a decision, their proposed order?
Well, they look at the agenda, post the agenda.
Which is how long in advance?
Usually it's the Friday before.
Is that in the rule?
No.
So, is that where, because, okay, so I understand his point. I mean, we have to kind of, what if the night before it pops up and there's another, and there's another, and one of the affected parties don't know that their case is up. You mean it would have been on the agenda?
It would have been on the agenda.
And the current practice is that roughly, I know that there was a time when I got a call from somebody who said, I didn't get a copy of the proposed order, this is going back a few years, until after the board meeting was held. So the issue is giving people some kind of notice.
Well, I think this actually would work better because you're not relying on the U.S. mail,
Right.
right? I mean, so,
Right, but we currently mail the proposed orders out at around the same time the cases go to the board members, correct?
yes.
Because that in the rule.
Right. Well, the current rule requires us to mail a copy. The current rule requires us to mail a copy of recommended decisions prior to the board considering them. There's a question about whether, and I don't think a proposed order is a recommended decision. So this is a carryover from when the board still had hearing officers. So, you know, the oath R&Rs are automatically mailed to everybody, all the parties. So it's just very redundant for us to have to do all these mailings, and I think having it up on the website is a much more efficient way to handle it. And as you already pointed out, it gives even more people access
Right.
to the proposed orders, which I think is a good thing.
Right, and I don't object to that. As it is now, in reality, the parties may get the report and recommendation from the oath judge a year before I get it.
Right.
But at a point in time where I think the more opportunity the board has to be transparent and ensure the trust of all parties in the process, if under some future administration, the board proposed orders got posted at noon and the board met at 2, that would be a travesty.
So I think what the best, my opinion as to the best way to approach it is, let's leave it flexible for now. If there seem to be abuses, then I think we can revisit it. But I'm personally am very much against putting in a time frame in this particular rule because it's not something that's required to begin with. So we're going an extra step and putting restrictions on ourselves that I think would be bad. And we should keep the flexibility. So, but again, you know, whatever the board wants.
But you would agree that the way it's now pegged to issuing a decision.
Well, I think we should change it to prior to consideration by the board. Right? Staff must post proposed orders on its website. That I agree with. But in terms of putting in a definite time frame, no. So the only other one that I think is really, a proposed order shall not be part of the record of the case. I don't see that as controversial. We did change a will, there was a suggestion to change a will to a may in 132A, so that makes a difference. The board may only consider.
I'm sorry, can we go
application.
back to 131?
Yeah,
A proposed order shall not be part of the record of the case,
right,
meaning that if the order is modified, that the fact that, oh, the board initially proposed this, but they changed it to that, would be outside the record.
correct. Okay, and then so in one.
That's what I'd like to give some more thought to.
Well, it's not part of the record of the case now. I mean, it's just codifying what's already true. Okay, you can give it more
Well,
thought.
if it's already true, why do we need to say it? So I just want to think through the ramifications of that.
Okay, 132A, changing the last sentence from the board will only consider an application for reconsideration to the board may consider an application for reconsideration only if the applicant establishes one or more of the following, which actually I think is better wording. It's not mine, but I think it's better wording. And the others were all ministerial changes. The last comment was to change, the last comment in 133B was to change a cross-reference, but I don't think we're changing that rule, so we don't have to change the cross-reference. That's it.
It's back to me.
So we accomplished everything but that one item, is that a true statement?
Which one is that?
The 130, Chuck had asked for more time to think about.
No, I think we have some open items.
The proposed order shall not be part of the record. Is that?
Other than that, we had a consensus on everything.
Yeah, right. We can finish more or less on
Let me just, Chuck asked more time to consider that before we even agree on it, right? That piece about the proposed order.
Right, so I'm just saying, everything else, we pretty much
Yeah.
had a consensus on it, and we're okay with it, except that one piece.
I believe so.
Yeah, I also want to look at some of the.
The definitions, right. I knew there was something else. Okay.
Okay, very good. Thank you. This will conclude our March 15, 2018 Loft Board meeting. Our next public meeting will be held here at 22 Reed Street on the first floor on April 19th, 2019 at 2 p.m. Thank you so much, everyone, and board members, please remember to turn in your attendance sheets.